An adult daughter calls our office and says, "My parents have a trust. They planned everything years ago, but someone has taken control of their finances." Her father had broken his hip. Her mother had dementia. A relative moved into the house to help. Within months, the trust had been changed. Hundreds of thousands of dollars had gone missing. Another family tells a completely different story. Husband calls and says, "My wife and I have had our trust for 20 years, but something's terribly wrong." His wife's personality has changed. She's become paranoid. She refuses to see doctors. She accuses him of conspiring against her whenever he wants her to see a doctor. Their trust required 2 physicians to certify incapacity of either party, in this case of his wife, before he could take control of their finances. But she refused to see doctors, so the incapacity trigger never activated, placing their entire estate at risk. She's giving large sums of money to strangers, and he had no legal authority to stop it. Both families believed they'd done everything right. They had trusts, they had powers of attorney, they had planned ahead. But when cognitive decline entered the picture, the system that was supposed to protect them collapsed. Over the next few minutes, we're going to be talking about why this is happening across Texas, California, and the rest of the country. Why traditional estate planning structures are beginning to fail in dementia cases, and fail catastrophically. Most importantly, we're going to discuss how families can design estate plans that actually work when cognitive decline begins. If this resonates with you, stick around. Hello, my name is Carla Hartley. I'm the managing partner for a law firm practicing in California and Texas in the areas of family and probate law. So you find yourself in a situation where you have a will, you've got a trust, or your parents have a will and a trust, yet everything seems to be spiraling out of control, and no one can seem to get the terms of the trust or the durable power of attorney to trigger. This is an increasing problem. If it's a problem you're facing, stick around because that's what I'm talking about in this video. Across Texas and California, we are increasingly receiving calls from adult children who begin with the same sentence. "My parents did everything right. They created a trust. They signed powers of attorney. They planned ahead. So why is everything falling apart?" What these families are discovering the hard way is surprising to them, but not so much to us, not anymore. The estate plan itself may not be broken, but the system that transfers authority during incapacity has failed. When that happens, families can find themselves trapped between cognitive decline, legal paralysis, and sometimes financial exploitation. The 3 control mechanisms estate plans rely on are 3 systems working together. Successor trustee manages trust assets. Durable power of attorney manages non-trust assets. Incapacity determination activates those authorities. Most estate plans rely on 3 mechanisms working together. The successor trustee takes over management of trust assets. A durable power of attorney allows someone to manage assets outside the trust, and a legal determination of incapacity activates those authorities. When these systems work properly, control transfers smoothly, but they depend on the assumption that often fails in dementia cases, that incapacity can actually be determined sufficient to be proven in a court of law. Typical incapacity language. Most trusts are going to require 2 physicians to certify incapacity. The legal framework for this in California is Probate Code Section 810 to 812. The legal framework for this in Texas is the Estate Code Section 751.002. Both rely on medical evidence of incapacity. Both California and Texas law define incapacity largely in terms of cognitive impairment and the ability to understand not just decisions, but the consequences of those decisions. Because of this, most estate planning documents require physicians, more than one, to certify incapacity before authority transfers. Sometimes this can be a physician and a pastor or priest who is well known to the family. In this age of megachurches, though, that person also often falls off the map. On paper, this seems sensible, but dementia cases often do not cooperate with that structure. Let me give you a real example of exploitation and isolation. An adult daughter named Rhonda had been helping her parents manage their finances for several years. Her parents, William and Carmen, had created a trust long ago. They had durable powers of attorney. Rhonda was named as a successor trustee in the trust and as a successor for the DPOA. Then William broke his hip. This occurred after Carmen was fairly well into and increasingly developing cognitive decline or dementia. A great niece named Shelley moved into the house to help. At first, that sounded like a blessing, but communication with Rhonda soon became difficult. Phone calls stopped being returned, visits became restricted. Shelley had effectively taken control of the household. During this time, Carmen signed new legal documents with a new trust attorney, a new durable power of attorney, and a new version of the trust. The new documents, which were not processed through the old attorney, removed Rhonda and placed Shelley in control. Over time, hundreds of thousands of dollars disappeared. Eventually, the situation required elder abuse restraining orders, conservatorship proceedings, and trust litigation. The court ultimately restored the original trust and imposed a constructive trust on a condominium Shelley had purchased with stolen funds. The estate plan existed. The transfer of control failed. These parties were exploited. Another case example. This pretty much happens when the system freezes up. This case illustrates a different failure. A married couple, Edgar and Eleanor, had a trust that had been in place for more than 20 years. They were joint trustees. Their son Ryan was named the successor trustee. The trust required 2 physicians to certify incapacity before authority would transfer. As Eleanor's cognitive decline progressed, her personality changed dramatically. She became intensely paranoid. She accused Edgar of conspiring against her. She refused medical appointments. Whenever Edgar suggested seeing a doctor or going to church, she said, "You're trying to put me away." Because of that refusal, the incapacity trigger never activated. Meanwhile, her physical health began to decline. Her brain no longer reliably signaled hunger or fullness. She stopped enjoying food. The only thing she consistently ate was ketchup. She was becoming malnourished. Ryan, the son, was deeply worried, not only about his mom's health, but about his father. From the outside, someone might accuse Edgar of neglect, but Edgar was doing everything he could. Meanwhile, Eleanor began giving significant sums of money to younger men she had befriended. Edgar could see what was happening, but legally he did not have authority to stop it. The estate plan had effectively frozen. America is aging rapidly. 57.8 million Americans are age 65 or older as of 2022. 78.3 million Americans are projected to be 65 or older by 2040. The population of 85 years and older is expected to double in that time frame. These situations are becoming more common for a simple reason. America is aging rapidly. The population over 85, the group most likely to experience dementia, is expected to more than double in the coming decades. And their estate plans are still following the old rules, the pre-dementia rules. Look at this boomer wave graphic. This generational chart shows the baby boom generation as having 76 million births between 1946 and 1964. As the baby boom generation moves into their 80s, millions of families will face the same challenges, which raises an important question. Why your parents' plan may be failing and why yours might too. Traditional estate plans assume cooperation with doctors, simple family structures, easy access to church, easy medical access. These assumptions are no longer reliable when the party who needs to be assessed has a vague impression that something's wrong and refuses to permit that assessment to take place. If your parent's estate plan is struggling under the realities of cognitive decline, what will happen when the same risks appear in your own life? That's what we'll explore in the next video.